Ryan, you and I have both litigated multiple eviction hearings. They can be intimidating even for us. What are some of the things that renters should know about the eviction process?
Well, now let's start from the beginning. Only a court can evict a renter from an apartment. The landlord can't do this based on their own initiative or can't just tell you that you need to move. An eviction is sometimes called an FED, or a forcible entry and detainer action. The landlord cannot evict a renter without first going to court. And before a landlord can take a renter to court, the landlord must first give the renter a written notice detailing the reasons for eviction, when the renter must move out by, and what, if anything, can be done to fix the situation. Also, this notice must tell the renter that an eviction will be filed if the renter does not indeed move out or fix the problem. This written notice is sometimes called a notice to quit. We've discussed the reasons elsewhere for eviction and how long the landlord must give the tenant to move out.
If, after giving a notice to quit, the landlord chooses to go forward with the eviction, the landlord must file the case in court. The filing fee is $150, and if the landlord succeeds in eviction, the renter can be forced to pay that fee on top of any damages or unpaid rent. Once the eviction action has been filed, the landlord will attempt to serve the tenant with a copy of the court papers, including the complaint and summons. You can't avoid an eviction just by dodging service of the complaint or summons. The landlord can get permission to post the papers on your door if he or she does not know where you are.
Now, if you receive the summons and complaint, you will also be given a court date, usually within the next 5 days or so. It can take place even before you file your answer to the complaint. Now, it's very important that you go to court and do not skip the hearing. If you do not go to court, a default will be entered against you, and you will be evicted from the apartment, probably 2 days after the hearing.
That's right. The only way you can defend yourself is if you go to court and tell your side of the story. Depending on why you are being evicted, you should bring with you any witnesses or any receipts or other documents you need to prove why the landlord is wrong about what you owe or your lease violation and why you should not be evicted.
Now, even if you do not have a good defense, you should still go to the court hearing. Sometimes you can work out a deal there with your landlord to pay your rent and stay longer. Or perhaps the court will give you more than the minimum 2 days to move out, especially if you have small children or some sort of physical disability. But none of this will happen if you don't show up. If you lose your eviction, you could be required to pay the landlord's filing fee, cost of service, and attorney's fees. The landlord will also get an order called a writ of assistance that will let the landlord call the police or troopers to forcibly remove you from the apartment if you aren't out by the date and time specified on the court order.
Evictions happen in 2 phases, both of which take place in Alaska District Court. The first phase we've just been discussing is the possession phase. It determines whether or not you get to stay in the apartment. But there is also the damages phase, which determines whether you have to pay the landlord for any damages caused to the apartment or for unpaid rent. You should file an answer to the eviction complaint within 20 days after you received it. This will serve as the basis for the second phase. There, you can also make any counterclaims against the landlord, such as for not making repairs to the apartment or not returning your security deposit. You cannot get a jury for the possession phase.
Now, it's always best that you remove all of your property from an apartment before being evicted, but sometimes it's not possible. Technically, though again, this is not a good idea, you can leave the apartment without removing all of your property. If this happens, or if you abandon the apartment even without an eviction, your landlord is required by law to give you a written notice that you have 15 days to remove any abandoned property left in your apartment after you move out. But the landlord can charge you rent for the days your property remains in the apartment. Your landlord can also move all of your things to storage and charge you the cost of the storage unit. Importantly, though, the landlord is not allowed to keep your property to pay off unpaid rent or to pay for any damage that you've done to the apartment.
After the 15 days are over, the landlord can sell anything that you have not removed. Many landlords are not aware of this law and immediately sell anything that you have left behind. Or the landlord might not let you back into the apartment to remove your things. If this happens and the landlord did not give you proper written notice, you can sue the landlord in small claims court for the value of what the landlord sold or threw away. Of course, it's best to avoid this. So if you are moving out and cannot remove all of your property in time, try calling your landlord to arrange a time to come and remove all the rest of your things.
Thanks. Well, that's the eviction process in Alaska in a nutshell.